significant health hazard or life-threatening in any
No,
way?
Judge.
All right, because I stated this to Mr. Landman, I am not going to, unless forced, issue a judgment against military personnel that's overseas serving. It's just not going to happen. I think I made that clear. To another judge to do it, that's fine, but I'm not doing it. That's bottom line. Court does call the case of Onyx Real Estate Solutions versus Jennifer Smith.
Buckle up, guys. Today we're diving straight into a courtroom moment that instantly sets the tone. Before any case is even called, the judge makes his position crystal clear. He draws a hard line, stating he will not issue judgments against military personnel serving overseas, unless absolutely forced. This isn't routine procedure. It's a statement of principle. Right away, you know this courtroom isn't just about paperwork. It's about judgment, discretion, and real-world consequences.
Good morning, Your Honor. Attorney Hamza Sob on behalf of the plaintiff.
Your name?
Jennifer Ruth Smith.
All right, where are we on this?
Your Honor, we entered into a consent agreement. Currently, the rent to retain is $4,000. Court costs are $175. The total outstanding balance is $4,175. Under paragraph 10 of the proposed order, it states defendant shall pay $835 starting July 21st, 2025, and then every month moving forward on the 1st till the balance is paid. Defendant must also stay current with the rent moving forward. And then Ms. Smith has signed the proposed order as well.
All right. And so it's $835 plus rent.
Yes,
Is
plus
what's
the
gonna
$925.
All right.
I'm finally back to work.
Pardon?
I'm finally back.
Finally back. Great. All right. And you have any questions regarding this consent judgment, ma'am?
Just if something comes up, what happens to me?
Okay, what do you mean?
I was dealing with cancer
Yes.
and I had to take time off work for that.
Okay.
So I'm still not 100% in the clear, but I'm doing everything that I can to maintain employment and hold on to my home.
All right. Well, let me.
I apologize for the bad handwriting, Your Honor.
Pardon?
I apologize for the bad handwriting.
Yeah. I don't think.
I do believe
I don't
the
think
amount
there's
is
enough.
below.
I'm sorry to make this up, but anyway, if you don't pay this, they can seek to get an order of eviction.
Okay,
Okay.
so communication.
Yeah, I would think so. I would say this, that under your circumstances, I would hope they're obviously working with you. But it seems to me if you get through, or as you're working through this, if for whatever reason something happens, I'll put it this way, I would hope that plaintiff would work with you as best that they can.
All right, thank you.
All right, so I'll have that message sent. And if not, then you can always file a motion with the court,
Okay,
seeking some type of relief because of circumstances you couldn't anticipate. All right?
thank you.
How's that for an answer?
Thank you.
Is that all
Your
right?
Honor. It alleviates some stress in my head right now.
Yeah, okay. And so I will sign this. Did you apprise her of the 3-day rescission?
I have not, Your Honor.
All right, ma'am, I've signed the judgment. You have 3 business days to think about this judgment. If you think that there's some legal reason, some right you didn't assert, or some other confusion on your part, you have those 3 business days to file a motion with the court to have the court consider setting this aside.
Okay,
Doesn't mean I will, but you have that time period to do that.
all right, thank you.
Okay? Good luck to you.
Thank you.
Thank
I'm going
you, Your
back to
Honor.
work.
Have a great day.
All right, guys, the first case unfolds as a standard rent dispute, but it quickly becomes something deeper. Jennifer Smith faces arrears, numbers are laid out, and payment terms are discussed. Then the mood shifts when she explains she's been battling cancer and struggling to stay employed. The judge listens carefully, explains the legal risks, but also acknowledges her reality. This moment shows the tension between strict enforcement and human compassion inside a courtroom.
Court does call the case of Mrs. Haverkamp LLC versus Chase Hyatt.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Chase Hyatt.
All right.
Your Honor, Mr. Hyatt and I have come to an agreement. The amount of rent that's owed is $775, court costs of $175 for a total of $950. We've agreed that that amount has to be paid by July 21st, or he could be evicted. He says he's made some payments that I'm unable to verify, but He said he'll have the whole thing paid by next Friday. So I think the 21st works. And I'm getting
This
old.
is, in the form of a consent judgment.
Yes, consent judgment.
All
I
right,
don't remember whether I advised him of his rights under the court rule.
that's fine. All right. And you have any questions regarding anything on this judgment?
No.
All right. I would have, I'm gonna sign off on the judgment and then that by consent, you do have 3 business days to think about this. If you believe that there's some legal reason, some confusion or some right you didn't assert, you would have to file a motion with the court within those 3 business days to set this aside.
Okay,
Understood?
yes,
Have a great weekend.
thank you, Your Honor.
Court does call the case of Sandy McFiddish versus Jamie Leslie.
Now we see the court lock things in procedurally. The judge signs the consent judgment, but pauses to explain something critical, the 3 business day window. He carefully tells the defendant she has time to reflect, challenge, or raise legal issues if something was misunderstood. This part may seem calm, but it's vital. It highlights how the court protects due process, even when a judgment is already signed.
Hello.
I'm Jamie Leslie.
I gotta have numbers first. Your Honor, David Fantier, on behalf of the plaintiff, I have a signed conditional dismissal in this case, the rent owing in the amount of $2,071.24, court costs of $175 for a total of $2246.24. Miss Leslie and I have agreed to a payment plan where she's going to pay $2,000 a month starting August 15th. Her rent is normally $1,465. So she's going to basically be paying $2,000 by the 15th. $1,465 will go toward the current rent and late fee. An additional $535 will go toward that balance. It'll basically take 4 months to get caught up. I think she's going to make partial payments. I told her I don't really care as long as the whole thing is paid. As long as when I look on the balance on the ledger on the 16th, I show.
In this segment, the court moves swiftly through another agreement. Rent owed, court costs, and a deadline are all placed on the record. There's no emotional testimony here, just clarity and confirmation. The judge again reinforces the 3-day reconsideration rule, showing consistency in how these cases are handled. It's a reminder that even straightforward cases carry serious consequences if terms aren't met.
$2,000 since the previous month. And so I think.
Oh, okay. So it's not part of the agreement, but you're thinking you may be able to have some extra money that you can put
Yes,
forward, try to get it done.
yes,
Okay, all right. Is that your understanding?
yes.
All right. Did you have any questions regarding this conditional order dismissal?
No, thank you.
All right.
She did ask for a copy.
Yes, sorry.
She asked me for a copy. She didn't just say it to you, but she asked in the hallway.
I don't make copies. What do you? No, we'll take care of it.
Okay,
All right. So I will sign off on the conditional order dismissal. You do have 3 business days to think about this. If you believe there's some legal reason, some right you didn't assert, or some confusion on your part, you'd have to file a motion within that time frame.
Okay.
You understand that?
yes.
All right, thank you.
Okay.
Ms. Weidling will get a copy for you just momentarily.
Okay.
Just have a seat.
Here, the focus shifts to a conditional dismissal with an aggressive repayment plan. The plaintiff outlines monthly payments designed to bring the tenant current over time. The judge steps in to confirm understanding, making sure both sides are aligned. This moment reflects how courts often act as referees, ensuring agreements are realistic and clearly understood before they become enforceable.
Court does call the case of YPF 16 versus Christina Morgan. And Terry Jones.
David Fantier, on behalf of the plaintiff.
Your name?
Morgan.
All right. And where are we on this?
Your Honor, we had a chance to go over her ledger in the hallway, and we've got her balance is now down to $313, which she agrees is correct. She said she's going to pay that next Friday. So I've got to be here next Friday at 1 o'clock anyway. Can we adjourn this till next Friday? And then if we come to court and she's got it down to 0, I'll just be dismissing.
Okay. That sound good to you?
Absolutely.
Okay, so I just want to make sure logistically, so we're clear. When are you gonna pay that? Are you gonna pay that on Friday?
Friday morning, just like.
Friday morning?
But she pays it online through her
So you'll be able
card.
to see it.
She'll be able to show me and I'll
She'll be able to
verify.
show you. Okay, all right. I was just trying to see if there was a way to do it where she didn't have to show, but I get it. That we'll do it that way. All right. So I will adjourn this then to July 18th, 2025 at 1 p.m.
Thank you.
All right, thank you.
Thank you.
Have a great weekend.
This case brings a different energy. The balance owed is small, the communication is cooperative, and the goal is resolution rather than punishment. The judge adjourns the matter to give the tenant time to pay and potentially dismiss the case entirely. It's a quiet but powerful example of how courts can reduce conflict when both sides act in good faith.
Court does call the case, YPF 16 versus Marla Borders.
We don't have any.
Good afternoon, Your Honor. David Fancher on behalf of the plaintiff.
Your name?
Marla Borders.
Thank you.
Your Honor, I've got a conditional dismissal on this case also. Her current rent is $3,285, court costs of $175 for a total of $3,460. We've agreed that starting August 5th, she's going to pay a total of $1,527.50 per month. And the reason we're doing it that way is her lease actually goes through next March. So we spread the $3,460 over that 8-month period.
Got it.
So she's going to pay $1,527.50. $1,095 will get applied towards her current rent and late fees. And then the remainder will be applied towards her arrearage. And I think that'll work out just fine.
All right. Is all of that correct, ma'am?
I agree.
All right. Do you have any questions regarding anything on here?
None at this time.
All right. And just also to apprise you, you do have, I've signed the conditional order of dismissal. You have 3 business days to think about it. If you believe that there's some legal reason, some confusion, or some right you didn't assert, you'd have to file a motion with this court within that time frame. You understand that? All right, very good. I will sign that. Thank you, ma'am.
Now I'm done with your honors. Have a great weekend.
You do the same, sir.
Now we're looking at a longer-term arrears problem, handled with structure instead of force. The repayment plan stretches across months, carefully tied to the lease term. The judge verifies every detail, confirms agreement, and signs the conditional dismissal. This segment shows the court prioritizing stability, keeping housing intact while still holding tenants accountable.
And Mrs. Haverkamp versus Decker, that matter's dismissed on things.
Sorry, I forgot.
No, it's okay.
Mr. Decker is in too.
Oh, is it?
Yes.
All right, Mr. Decker?
Hello, sir. Can you hear me?
Okay, yes, we can hear you. They
Alright.
dismissed the case. You have a problem with that?
Dismissal? Not at all, sir.
I didn't think so. You don't have to smile so much. All right.
Hey, it's a good thing, man. It's a blessing. I don't have too many stress and problems anymore, boss.
All right. All right. You take care. Have a great weekend.
You as well, sir. Thank you.
Thank you.
Thank you.
Arbor Meadows versus Karen Contreras Hernandez.
Fronting for the plaintiff.
I think there she is.
This brief moment delivers instant relief. A case is dismissed, and the defendant's reaction says everything. The judge even adds a touch of humor, acknowledging how rare stress-free moments can be in court. It's short, but it humanizes the process, reminding viewers that courtroom victories, even small ones, matter deeply to the people involved.
All right. Your name?
Karen Contreras Hernandez.
All right. Where are we on this case?
This is a termination of tenancy matter based on failure to maintain the residence.
All right. I don't think you were here at the last hearing.
I was not. I was attorney of mine, I believe.
And she's overseas serving our country. You're aware of that?
Attorney Landman did indicate that she had said that. We don't have any proof of that other than her statements, but I'm not.
I can look in her background. I also saw some uniform and military paraphernalia at the last hearing, and I'm gonna tell you, she's overseas.
I'll take her word.
All right. I mean, I'm not gonna even question that part of it. But given that fact, my understanding is there's something that has to be moved from the unit, from the property.
Outside the unit.
Pardon?
The trailer, just assorted things need to be relocated.
Okay, and my understanding, I think the gentleman that was here the last time, was that Mr. Contreras, ma'am?
Correct.
That-
My husband.
Okay. he had indicated that they were basically waiting for her to come back stateside. That's my understanding.
Correct.
And when is that anticipated to occur, ma'am?
Okay, so I should be back. I want to say within like a month, maybe a little bit longer. But
All
that's
right.
now. Mhm.
All right.
I don't have an exact date.
Pardon?
I don't have an exact date.
Gotcha. Yeah, I understand. So, although there's the condition that's there, is anything regarding that condition a significant health hazard or life-threatening in any
No,
way?
Judge.
All right, because I stated this to Mr. Landman, I am not going to, unless forced, issue a judgment against military personnel that's overseas serving. It's just not going to happen. I think I made that clear. If you want to take it to another judge to do it, that's fine, but I'm not doing it. That's bottom line. So what I'm going to suggest, if she's anticipating being back, then I'm going to say put it out a month. Let her get back, or at least a month, and let her get back, and then assess the situation and try to figure out what to do.
That's understandable, Your Honor.
All right. All right. And what branch did you say you were in?
Army?
Oh, that's right. So maybe I'll change my mind. No, I'm kidding. All right. Why don't you give me a date about 35 plus days out, please?
August 15th at 3 p.m.
All right. I'm going to adjourn this to August 15th, 2025. You said 3 p.m.?
Yes.
At 3 p.m. Okay.
And this will be an in-person, correct?
This will be an in-person hearing. If for whatever reason you're not back, then what you can do is you can sign in, or somebody can let us know that you're not coming back at that particular point in time, and we'll figure something out.
Okay.
Okay?
Yes. Thank you so much, Your Honor.
All right, ma'am, thank you very much for your service. Do appreciate it. It's because of people like you that I get to do what I get to do every day, and I'm grateful, always. All right? Take care and please be safe.
Thank you. Bye-bye.
Bye-bye.
This is one of the most powerful segments in the entire video. The court confronts a termination case involving a tenant serving overseas in the Army. The judge doesn't hesitate. He refuses to issue a judgment, defers the case, and openly thanks her for her service. This isn't just legal discretion, it's moral clarity. The courtroom becomes a place of respect, not punishment.
Court does call the case of Beagle Properties versus Carlos Hicks.
Printing.
How you doing? What's your name?
Carlos Hicks.
All right. And what are we here on? We are here on a...
Defendant's motion to set aside the default judgment, Your Honor.
All right. And what's your basis, sir?
Huh?
What's your basis? So why do you want this judgment set aside?
Because literally just got relocated to a condemned spot.
Say that again, please.
I got relocated to a condemned.
Okay. So we back up. You were at Arbor One.
Mm-hmm.
Then you went, they relocated you to
the
villas
townhouses
across the street.
And that's even worse. I haven't had no hot water since 2 months, 3 months.
Okay. And so did you sign a new lease with them?
I never signed a new lease. I still have the old lease from last apartment I was in before they relocated.
Okay. So the only lease you have is the Arbor One lease.
Yes.
Okay. All right. So Mr. Hicks, when they moved you to the villas over across, right? To your understanding, what was the arrangement of what your tenancy would be?
When they moved me, I was still active going to a court with y'all before. So I was still active in court with y'all. So when they relocated me, I was still active going to court with me. with y'all. So I still got
Right.
another court date with y'all.
And
August.
that was when they were before me and I was telling them they needed to relocate people.
Yes.
And so then they moved you over there.
Mm-hmm.
Did you sign anything saying that you were going to pay rent?
No, I never signed nothing. They just said you getting a relocation. They gave me my keys and told me my apartment, and I was moved in, and they moved me in. I don't have no lease or no like that.
So I'll hear from you in a second, Ms. Kim, but
And then they only want $800, and I've been living there for like 3 months, so the math don't add up. They only want $800, and I've been living there for like 3 months, and the math don't even add up.
no, so I hear you kind of on that. They took a judgment for 1909.
Tension spikes here as a tenant explains being relocated without a new lease, living months without hot water, and facing rent numbers that don't add up. The judge digs into the facts, questioning how obligations were created without proper paperwork. This segment exposes how housing disputes can spiral when procedures aren't followed correctly.